Hi, Group 9 is going to talk about Chapter 4 Lifting of Corporate Veil. Introducing our team members.
This is the definition for lifting of the corporate veil. It is a situation in which courts put aside limited liability and hold a corporation's shareholders or directors personally liable for the corporation's actions or debts. While the law varies by state, generally courts have a strong presumption against lifting the corporate veil, and will only do so if there has been misconduct like abuse of corporate form or undercapitalization at the time of incorporation.
To avoid corporate veil piercing, firstly is protecting your asset. If you are a business owner, one of the most significant reasons to incorporate or form a limited liability company is to protect your personal asset from a business creditor's claim against your company. Second is separating personal and business asset. If you are the owner of a corporation or an limited liability company, you are obligated to maintain a legal separation between yourself and your company. Lastly is observing corporate formalities. Every state has a certain requirement for corporations and limited liability companies. Filing an annual statement or annual report is one of these requirements that apply to both types of entities.
There are two major grounds which corporate veils may be lifted. The first one is statutory provisions. For example, under Section 36, where one remaining members and carries business for more than 6 months are liable to pay all debts. Second is by judicial grounds. For instance, corporate veil is often used for tax evasion or to escape some kind of tax liability. In such circumstances, the courts raise the company's veil to reveal the company's true state of affairs.
One of the example cases of lifting the corporate veil is Daimler Co. Limited versus Continental Tire Co. German national residing in Germany floated a company in London for trading in tires manufactured in Germany. On a suit for recovery of debt filed by the company during First World War, the defendant argued that if the debts are repaid, it will amount to trading with enemy, held that a company will be regarded as having enemy character if the person having de facto control of its affairs are resident in an enemy country or wherever they may be are acting under instruction from or on behalf of the enemy.
Okay, here is the topic that I'm going to talk about, the cases about lifted veil of the company law. In Wolfson versus Strathclyde Regional Council, it was held that the veil could be pierced where special circumstances exist, indicating that the company is a facade concealing the true fact. In Webb Dalby at Brougham, which dates back to 1911, the veil was lifted where Carroll Frosted had incorporated companies to disguise their true involvement as sole. This is the plaintiffs of the court. In that case of Guilford Motor Company versus Horn, the defendant. This is the defendant of the statement who was managing director of the claimant, set up a separate company in his wife's name so that he could solicit customer of the claimant during and after his employment. So this is the defendants of the cases in court. In Jones versus Littman, the defendants attempted to evade a contract for the sale of land by transferring it to a company. The court lifted the veil and required specific performance from both the defendants and company. In Truster versus Smallbone, a director of the claimant stole money from the trusted and paid it to his own company, Intercom. This is kind of cases. And they also have plaintiffs about the court and defendants about the cases.
As a result of incorporation, an incorporated company wears a corporate veil. and thus acquires the corporate personality behind which there are shareholders, members who have formed the company. Although in law the company has an independent personality, it is an artificial person, and hence, behind the corporate curtain, there are natural persons, example shareholders. This corporate personality may be unveiled in certain situations where it is used for illegal or fraudulent activities, and the shareholders or the directors behind it may be held responsible.